The major Supreme Court cases of the 1960s. This is the JFK, the LBJ era, and this is still the Warren Court. This is the same Chief Justice and some of the same Supreme Court justices that presided over the Brown versus Board of Education decision. On that Supreme Court, we have liberal judges: William O. Douglas, Hugo Black, William J. Brennan Jr. And what that means is that if we say somebody is a liberal judge, it means they're willing to go against court precedent. They're willing to make rulings that run counter to what the court has said in the past. However, we also have John Marshall Harlan and Felix Frankfurter. These are conservative judges who preferred to show judicial restraint, meaning they preferred to rule in the manner that the court had ruled in previous cases. In 1962, Frankfurter resigns, and JFK appoints Arthur Goldberg. He had been the Secretary of Labor. He was a very liberal-minded judge. And this is part of the reason we have so many landmark decisions in the 1960s. The one we probably hear the most about today is Engel versus Vitale. And this is a result of a policy in the New York City public school system, where each day was being started by a prayer led by school officials. Now, some parents in New York City didn't like this. Some parents in New York City challenged this in court, and it goes all the way to the Supreme Court, where the Supreme Court, the Warren Court, ruled that it is unconstitutional for state officials to compose an official school prayer, and it's unconstitutional for them to encourage its recitation in public schools. This is a violation of the First Amendment. Another important one happened in 1962. This was Baker versus Carr, and this had to do with congressional representation in Tennessee. We demonstrated this in one of the classes, where Tennessee had been divided along geographic boundaries. But as more and more people started to move to urban areas like Memphis and Knoxville, they never redrew the lines. And as a result, you have representatives representing a whole lot of people from those urban areas, and then you have different representatives representing just a few people from the rural areas. The Supreme Court said this isn't fair, said this was unconstitutional. They said that congressional and legislative representation must be allocated based on people, not on the amount of land. They said that one man should count for one vote. No person should be have more political influence or less political influence based on simply where they live in their state. This ruling dramatically increases the power of urban areas, of cities, and it also dramatically reduces the political power and influence of rural areas. And the court went on to say that if districts are not fairly drawn, then federal courts have the authority to draw up those legislative and congressional districts. Another important case, especially for the women's movement, was in 1965, Griswold versus Connecticut, in which the Supreme Court ruled that birth control is legal, that it cannot be banned by state or local government. And this was based on a right to marital privacy. And this is important because this is one of the first times that the Supreme Court has said that people have a certain right to privacy. It relates to birth control, but it's also been applied in other circumstances later. In 1967, the court also ruled in Loving versus Virginia that race-based restrictions on marriage were unconstitutional. Virginia and a number of other southern states had banned interracial marriages. And in Loving versus Virginia, the Supreme Court said that those types of restrictions were unconstitutional and that interracial marriages are legal and protected by the Constitution. The following all have to do with the rights of the accused. The first one is Mapp versus Ohio, and this case ruled that evidence that was obtained by an unconstitutional search, by an illegal search by the police, cannot be used in court. In 1963, Gideon versus Wainwright said that defendants must have lawyers provided for them. Mapp versus Ohio, Gideon versus Wainwright, and these other court cases that we're going to talk about with the rights of the accused were already established principles in federal courts, but most trials are not in federal courts. Most times when people break the law, they go to a state court. And what Mapp versus Ohio and Gideon versus Wainwright and Escobedo versus Illinois and Miranda versus Arizona, what all of these are going to do is establish that the rights that the accused have in federal courts extend to state and local courts. The same rules hold true. So in a federal court, they can't use evidence that was obtained by unconstitutional search. Mapp versus Ohio is going to prove that that applies to state court level cases. Gideon versus Wainwright says that defendants must have lawyers provided for them, whether they're in a federal court or whether they're in a state or local court. It's guaranteed by the Constitution, so it had always been followed in the federal courts. This case, though, is going to apply or extend that or incorporate, that's the vocabulary word, incorporate that principle to state courts. Escobedo versus Illinois is going to take another federal principle that had always been applied in federal courts and incorporate it into state courts. And Escobedo versus Illinois is going to apply the principle that people have to be informed of their constitutional rights. This is often confused with Miranda versus Arizona. And what the Miranda case incorporated was that you could not be interrogated, nor could you give a confession without your attorney present.